What is that?
Eye drops.
I like that eye drops.
Brady's most recent Costco purchase for Trigg.
That's Emilie Kiser, TikTok mom, influencer, in the face of a seemingly picture-perfect family life. But just weeks after filming that moment with her son Trigg, tragedy struck. And now, nearly 2 months later, it is being reported that Chandler police are recommending a felony child abuse charge against Emilie's husband, Brady Kiser, after 3-year-old Trigg drowned in the family's backyard pool. We're going to break down the latest in this developing case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Nearly 2 months after 3-year-old Trigg Kiser drowned in his family's backyard pool, Chandler, Arizona police have recommended a felony child abuse charge against his father, Brady Kiser. The case is now in the hands of the Maricopa County Attorney's Office, which is going to determine whether or not to move forward with formal charges. But this incident has drawn widespread attention, in part due to the family's very high profile. Trigg's mother is Emilie Kiser. She is a well-known social media influencer with millions of followers. Now, if you haven't been following the case, here's just a quick recap of what police say happened. We go back to May 12th, 2025. 3-year-old Trigg Kiser was found unresponsive in the backyard pool of the family's Arizona home. He was rushed to a hospital, but died 6 days later on the 18th. Horrible situation. Now, according to the police, Trigg was under the supervision of his father, Brady Kiser, at the time. His mother, Emilie, was out with friends. So investigators, they allege that Brady was negligent in his supervision of both Trigg and the couple's infant son, who was also under his care at the time. The Chandler Police Department shared an update on the investigation on July 15th. This is via X, formerly Twitter, writing, "We have completed our investigation into the tragic drowning of 3-year-old Trigg Kiser. After a thorough review of the evidence, we have submitted the case to the Maricopa County Attorney's Office for further review and any potential prosecutorial decisions." Now, the attached memo reads, quote, "Investigators have recommended a Class 4 felony charge of child abuse against Brady Kiser." And that recommendation falls under Arizona Revised Statute Section 13-3623, which states, under circumstances likely to produce death or serious physical injury, any person who causes a child or vulnerable adult to suffer physical injury, or having the care or custody of a child or vulnerable adult who causes or permits the person or health of the child or vulnerable adult to be injured, or who causes or permits a child or vulnerable adult to be placed in a situation where the person or health of the child or vulnerable adult is endangered, is guilty of an offense as follows. Now, because Chandler police allege that Brady Kiser acted essentially with criminal negligence, they have recommended this Class 4 felony charge under the statute. And according to the law, if done with criminal negligence, the offense is a Class 4 felony. And here's where this case has now drawn national attention, because Emilie Kiser, as I said, is no ordinary mother. She is a major social media influencer with more than 2 million followers on Instagram and more than 4 million on TikTok. Her content often centers around family life, portraying a picture-perfect household filled with warmth, routines, relatable parenting moments, and a couple of her most popular videos shows what a day in her life raising kids looks like.
He's like, you want Handy now?
You're not smiling at me. You're smiling at the fan. So cute.
And other clips capture the picture-perfect moments, the kind of wholesome, family-centered content that helped her build such a massive following. So to help me break all this down, I want to bring on a special guest, Bob Bianchi, criminal defense attorney, former prosecutor, who, by the way, I don't know if a lot of people know this, is also an EMT. Bob, in all of the years, I didn't even know, or I apologize if you told me, I didn't realize you're an EMT.
Yeah, Jesse, I've been, since I was a teenager. I took a break for a while and I got recertified, and I'm riding on my rescue squad, and I love it. And, you know, it kind of fits into a lot of the crime aspects of the things that we do. People know me as a homicide prosecutor, but way before I was that, I was a guy who was literally taking people to the hospital who were involved in murderous situations.
Well, that's why your expertise, I mean, I love having you on anyway. You have great expertise, but now you provide a different layer because, particularly with this case, because I want to walk through exactly what apparently happened on the day this whole tragedy unfolded. So we go to 7 p.m. on May 12th, and first responders were called to the Kiser family home in Chandler for a report of a possible drowning. And officers arrived quickly. They performed CPR on this 3-year-old Trigg until firefighters took over. He was first taken to Chandler Regional Medical Center, then transferred to Phoenix Children's Hospital in critical condition. Bob, let's stop right there. First, how critical is that timing? You know, you're dealing with somebody that young. Do they have less of a chance of survival? Do you need to act more quickly when you're dealing with somebody that young?
Yeah, I mean, with a person that's young, hypoxia or the lack of oxygen is something that is going to affect the younger you are. And typically most cardiac arrests are really oxygen-related issues, respiratory issues, as opposed to adults where they become heart rhythm issues. The bottom line is that the brain, when it's deprived of oxygen for minutes, deteriorates very, very quickly. And at a certain point in time, you get to a point where the body may be quote unquote alive, but the person is brain dead. And I can just tell you, Jesse, from my experience as an EMT, and we were just recently talking about it, no matter how experienced and how many years you do this, when you get the call to go in and you know you're dealing with a cardiac situation or a breathing situation with an infant, no matter how experienced you are, the tension ratchets up tremendously because the stakes are so high. So these are calls that are nightmarish, even to professionals like myself.
On Sidebar, we talk so much about the law. How could I not talk about our sponsor, Morgan & Morgan, America's largest injury law firm? This is a firm with over 1,000 attorneys. You know why they have so many? Because they win a lot. They have recovered over $25 billion from more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million, 40 times the insurer's $650,000 offer. Another client, Pennsylvania, received $29 million, and this after being offered only $500,000. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so easy. You can start a claim from your phone in just 8 clicks. So if you're injured, you can simply start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. What is the first thing somebody should do if they see a child who's in the pool drowning and they take them out? What should they do immediately to try to save the child?
Well, the first thing that they should do is make sure they're calling 911 and that they have somebody that's responsible that's going to get emergency services there as quickly as possible. They're going to check to see whether the baby is breathing or whether the baby is whether it's pulse and respiration. And depending on that, if the baby is choking, you're going to try to give rescue breaths. The main thing is to make sure that the heart is pumping and that you're giving rescue breaths. And the public service announcement that I would give to people is that we could save a lot more people, especially if parents have not gone through a CPR class, because CPR for a child is different than CPR for an adult. You need to do that. You need to be ready so that when we get there, it's not too late.
So, Bob, I'm going to ask you to now put on your legal cap because I want to get into this. According to police records, Brady Kiser apparently told investigators that he had been distracted caring for the couple's newborn and lost sight of Tig for approximately 3 to 5 minutes until he discovered him unresponsive in the pool. And Brady also apparently acknowledged that while the family typically used a protective pool cover, it wasn't uncommon for Trigg to play near the uncovered pool. Now, the investigation officially began the very next day, May 13th, when Chandler police filed search warrants to obtain backyard surveillance footage, hoping to verify Brady's account of what happened. Now, on the other point of this, sadly, after spending 6 days in critical condition, Trigg passed away at Phoenix Children's Hospital. The Maricopa County Medical Examiner later ruled his death an accidental drowning. But interestingly, the Arizona Republic reports that police had already been considering potential child abuse charges against Brady even before Trigg's death. That's according to search warrant applications that were filed earlier that month, suggesting there may have been previous concerns. So, Bob, now I go to you. A lot to break down here. First of all, the apparent admission. How much could that hurt him legally if he was distracted looking at his other child or caring for his other child, or is that a legitimate defense?
Okay, it's a lot to unpack here. First,
Yeah.
Jesse, I have to say, I find it extremely distasteful as a prosecutor who believes in a system that's supposed to run and everybody given due process, that police are releasing a finding during an investigation when it's going to the prosecutor. And ultimately, the prosecutor is the person who makes a decision as to whether or not the facts of a particular case implicate a violation of the law. What the cops have done here by releasing this is create an incredible torrent of public pressure. And the last thing that we want is to have public pressure involved when prosecutors are making decisions. Despite my having been the head prosecutor, we were appointed. We weren't elected. So we were able to act a lot freer. But I have to say, a lot of my colleagues were concerned about how the public was going to view the prosecution. And the police put a lot of weight on the prosecutor by doing this. Maybe that's the way they do it out there. That practice to me is not appropriate.
Can I stop you right there? Could the police say, hey, listen, we wanted to make it clear where we stood. We wanted to make it clear that he should be charged. Or can they come out with that? If they say, if they're asked for a comment and they basically say, we're not going to comment, we'll speak with the prosecutor's office. Maybe they say something simple as that. The prosecutor's office decides not to bring charges. Can they then come out and say, hey, we recommended it, they chose not to? Do they only do that afterwards?
I mean, I'm not saying you can't do it or there's anything that's illegal about doing it, but I can only tell you from the jurisdiction that I came from, and most of the jurisdictions that I know of in New Jersey, not that we're, eminently correct in everything we do, there was a chain of command how information was released to the public so that the prosecutor was free to make its prosecutorial decisions without worrying about the court of public opinion. So where I came from, this would never happen. The information and the fact gathering would happen with the police and the detectives from my office. It would then come to either my assistant prosecutors or myself for us to make the legal conclusion, because just by referring the case under an investigation now taints an individual. So if the prosecutors decide not to prosecute this individual because they don't think it rises to the level of a criminal offense, they will forever be tagged with people who they're going to be argued the police thought they in fact were responsible for this offense. And I just don't think that that's right. Not saying they can't do it, Jesse, but I just don't think in a situation like that, that you should be courting the public opinion. And I think that's happening in too many prosecutions, in too many jurisdictions, and it's all about what the public thinks as opposed to what the facts and law are. I was just, when I heard this in this particular case, I felt it was egregious, and I had to wonder whether this influencer, she's got millions of followers. Now the prosecutor's got to worry that the public is going to be upset that she's so important that they decided not to prosecute her. Just puts you in a tough spot.
That is 100. I completely understand where you're coming from, and I can't necessarily disagree. I just was curious what the police response argument would be to that. But putting that to the side, now we talk about what potential charges or charge could be here. Do you think there's a legitimate defense here that this was an accident? If you take everything as true, and if he was distracted, let's say not by his phone or he's playing games, but he's caring for his other child in some way, is that a legitimate defense? Either A, that the charges shouldn't be brought, or B, if he is actually charged and that's how he could defend himself at trial.
Yeah, it's a legitimate defense, but I'll have to back up and start with, sometimes we have to look at the law and prosecution globally. Prosecutors aren't there just to hit flies with sledgehammers. And if somebody just, dances a little bit out of line, hammer them. I always used to say, just because you can prosecute doesn't mean you should. And we repose a trust in prosecutors that they will know the difference on a case-by-case basis, that sometimes you need to prosecute because maybe the deterrence need is high. Maybe you need to send a message. Maybe you have a particular crime issue in your community. You need to overemphasize prosecution and there would be a penalty for it. So prosecuting a case like this is not just like one size fits all, at least in my opinion, it shouldn't be. Getting to the actual defenses, we have to be reasonable here. I know everyone will have a political opinion. Everybody, she's an influencer. You either like her or you don't like her, and that'll be the basis upon which people are going to start formulating their opinion. But let's not be so quick to judge. Parents make mistakes all the time, and but for the grace of God kind of thing, Jesse. I have had to handle cases in which parents who are extremely responsible backed their car up, struck their child, killed them. I've dealt with 4 or 5 cases in which situations happen where a child drowned in a pool. And there have been some cases that I have prosecuted for that and some that I haven't. Personally, my feeling was, as a professional, this family will live with this sentence of having killed their child for the rest of their lives. And there is a punishment to that. Secondly, I don't see a need for deterrence here. Parents aren't going to like have their kids going near pools, and this is not going to make it any better by putting the guy in jail or getting a conviction. Thirdly, I don't see anything about intoxicants. That's where I did prosecute. If you were under the influence, if you had previous history of abuse with the child, things of that nature would be aggravating to me and make me file those charges. The worst thing that I see in this case right now for him is the fact that he admitted to the point you were raising before, that the child was in the proximity of the pool on other occasions where the cover was not on the pool. So knowing that and knowing that you could be distracted would be the prosecutor's argument as to why, now listen to the law here, there is a gross deviation, not just a deviation, it's got to be a substantial disregard to a risk that's unjustifiable that another reasonable person, I'm sorry to throw a lot of terms out there, but they're making that reckless standard high. In other words, the prosecutors have to prove a lot. And the question is whether or not those factors, having previously known the child would be there and being distracted, will rise to that level. That said, if all things being equal, sorry to go on, with a case like this, if that happened, it was an unfortunate tragedy. I know good, decent, great parents that have found themselves in situations like this, I'd be inclined not to prosecute.
Yeah, I hear you. And I think the pool covering goes to that issue of foreseeability, which we always talk about so much in the law. I will say, do you think that it was the pool covering? Do you think it was potentially the surveillance footage, whatever was shown on that surveillance footage or potentially shown on that surveillance footage, that led police to move forward and say we're apparently recommending a charge here? So what do you think it is that they believe? The DA's office could disagree, right? They could say we don't think there's a legal case here. But what do you think it is from the police point of view that they believe a crime was committed?
Yeah, and the DA could say, I think there's a legal case here, but we choose to exercise our discretion not to prosecute it. It's hard to say, Jesse. I mean, maybe he said, I was only gone for 3 to 5 minutes or distracted. And by the way, what was he distracted with? I mean, this is what we're talking about, where we can go on and on. Let's say the infant that he was caring for was choking, for example. I'm just using a wild example. Well, would it be unreasonable that he would attend to that infant in the house that's choking, as opposed to, would that be a justifiable reason to be distracted? Or maybe they look at that tape and they find out that child was out there for 20 minutes unsupervised. It's very difficult to know the reason why they decided to make that recommendation without any more facts. I mean, we'll find out. Yeah. But if what he said are the facts and the cops decided to send it to the prosecutors for review, I got no problem with that. I think that's legitimate. It's just me personally.
I hear you. No, I hear you. I think you make a valid point. Do you think this whole conversation about this reporting that they might have wanted to bring charges against him prior to the pool incident, no idea what that's about, is that a factor in this case in some way?
No, I think we would have done exactly the same thing, because even if there wasn't a fatality, when you're dealing with child endangerment, it's affecting the health, safety, and welfare. There doesn't have to be a death on the other end of that in order to investigate. So I think they did exactly what they should have done. And plus, when you have a situation where resuscitative efforts were at play and the child was apparently in ICU and died 6 days later, you know, I've handled cases like this. We know that death is probably likely here. So there was no question this was a proper investigation. I wouldn't take anything, I think, to your point, that they investigated it, that there was something previous. I think they did it based on standard operating procedures.
Yeah, it's a curious aspect of it nonetheless. Okay, I want to move on to this part because the case takes another turn. We go to May 27th, so this is just 2 weeks after Trigg's death. And Emilie Kiser apparently filed a lawsuit to block the release of records related to her son's drowning. That included 911 calls, autopsy photos, security footage from the family's backyard. In the legal filing, Emilie's attorney wrote, quote, Emilie is going through a parent's worst nightmare right now. Emilie is trying her best to be there for her surviving son, but every day is a battle. Emilie and her family desperately want to grieve in private, but sadly, the public will not let them. Trigg's death has become a media frenzy. Appallingly, 100+ public records have been filed with both the city of Chandler and the Maricopa County Medical Examiner's Office. The records requested presumably reveal graphic, distressing, and intimate details of Trigg's death that have no bearing on government accountability. To allow disclosure in these circumstances would be to turn Arizona's public records law into a weapon of emotional harm rather than a tool of government transparency. And a footnote in the lawsuit reveals that neither Emilie nor her legal team have reviewed the sensitive records in question, including the police report or surveillance footage or 911 call or body-worn camera videos, the autopsy report, the death certificate. The footnote reads, neither Emilie nor Emilie's counsel have reviewed the investigative or post-mortem records at issue, including but not limited to, again, the police report, supplemental records, security camera footage of the accidental drowning, body-worn camera footage, scene photos, 911 recording transcript, autopsy report, autopsy photos, death certificate, because these records have not been made available to them, nor does Emilie ever wish to view them. On June 3rd, an Arizona judge granted Emilie's request to temporarily seal the records while the court reviewed her broader privacy claims. And then on July 9th, prosecutors and the medical examiner's office filed a motion requesting an exception to that order, arguing they needed access to certain documents to complete their investigation. And as of now, no ruling on that request has been made public. Bob, feels like she has a legitimate argument here.
Yeah, I think that was her defense lawyer or her lawyers articulated this very, very well. And I think the most important point was that there's nothing that's going to be hidden from the public because we believe in full disclosure. Now, each state has its own laws with regard to what it allows to be disclosed in an investigation. I could just tell you in New Jersey, for example, you would never get any of these records while there was an investigation going on, full stop, period, end of story. And that is to preserve the investigation, preserve the integrity of the prosecution, and moreover, to preserve the innocence of a person who may down the road not be, in fact, be prosecuted. So they're going to be pillared with all this information if it gets out, if prosecutors decide not to prosecute that person. Is that fair? Now, the other thing I have to say, though, Jesse, on the other end of that equation, I found it odd that the prosecutors were asking for an exception for themselves. I mean, I imagine the prosecutor would have access to everything. So I was confused by that piece, but certainly the prosecutors should have access to everything. They need to make the ultimate determination as to whether they can prove a case beyond a reasonable doubt and whether they're going to pursue prosecution here. I'll say one last thing. You know, people like me and you, Jesse, what a lot of people don't get is that when you get into the public world and you're in the public realm and you become quote unquote famous or a public figure, you expose yourself to a lot of this, unfortunately, and your privacy gets diminished. It's just like defamation, right? Your privacy gets diminished incredibly because of your public figure status. So I feel complete empathy for them, but in my mind, a judge is doing the right thing here, and this should not be released unless and until the prosecutors are complete with their investigation, state law permits it, and a charge is actually filed against them. If those three things are not met, then I, as a judge, if I legally in their state law, would not release these things.
Yeah, I can understand that. And you think about the difficulty they're going through, this loss, this pain, and the idea of that information being made public too prematurely. I mean, we already live in a world where people can manipulate data or misinterpret data and feed a narrative, particularly on social media, as her being a public figure. The danger I see is quite immense, but you know, it will be interesting to see how it plays out. It's such a tragic case because the family is awaiting the prosecutor's decision, the possibility of a trial that could further thrust this private tragedy into the public eye. Bob, I mean, let's just circle it up here. You said the prosecutors don't have to, you know, agree with the recommendation from the police. They may agree or have the discretion to choose not to move forward with charges. How much sway, how much influence does the law enforcement's recommendation have on the prosecutor's office, and what do you anticipate may happen here? I know it's not fair because you haven't seen the case file yourself, but what are you going to be looking out for?
I think that the police recommendation was, maybe it happens all the time, but from where I sit, not the right thing to do. These are elected district attorneys, I believe, out in that jurisdiction. So they're more attuned to having to be concerned about public opinion because public opinion translates into votes, which I've always hated. But nevertheless, that's the way it is in the circumstances. And now tremendous pressure has been placed on these prosecutors. Hopefully, they can use understand their power, understand the power of mercy, understand the power of that not hitting a fly with a sledgehammer, understanding that this family is going to go through a lifetime of horror and a jail in and of itself because their child is gone. And if in fact the facts are as we know them, that there was a father who was distracted, I'd ask the public to think about all the times you've been distracted, or things have happened and you're like, oh my gosh, thank God nothing bad happened. And just because something bad happened doesn't mean we should be prosecuting. If there's nothing else that we're aware of, no drugs, no alcohol, no previous instances, the father's story checks out to be accurate, I would hope that the prosecutors would say they're suffering a punishment enough, and I'm going to exercise my discretion under the law not to prosecute this case. And but I think the police have made that very, very difficult. It's easy for prosecutors, Jesse, last point, and I see this lack of integrity, lack of spine, lack of fortitude, where they use this phrase, we'll just present it to the jury and let them make the call. In other words, they're too afraid to make the call themselves and to put a person through the ringer, as it were, because they won't make the tough call. Make the tough call.
Bob Bianchi, thank you so much for coming on. Value your expertise as always. And again, thank you so much for the work that you've been doing and continue to do. A lot of people owe you thanks, Bob. Thank you so much.
Thanks, Jesse. Great to see you.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.